Hi friends, I am Krishna Kumar, Assistant Professor, School of Law, Dr. Hari Singh Gaur Vishwavidyalaya, Sagar, Madhya Pradesh. Today's topic of our discussion and learning is all about directive principles of state policy, the legislature, the executive and the judiciary. This lecture is divided into 8 modules. Module 1 is Introduction, Module 2 Objective of Directive Principles of State Policy, Module 3 Overview of Directive Principles of State Policy, Module 4 The Doctrine of Separation of Powers, Module 5 The Legislature, Module 6 The Executive, Module 7 The Judiciary and Module 8 The Conclusion. Coming on to Module 1 Introduction. An important feature of the Constitution is the directive principles of state policy. Although the directive principles are asserted to be fundamental in the governance of the country, they are not legally enforceable. Instead, they are guidelines for creating social order characterized by social, economic and political justice, liberty, equality and fraternity as enunciated in the Constitution's preamble. The directive principles of state policy constitute another important feature of Indian Constitution. It is an idealistic and philosophical chapter in the Indian Constitution, which contains various aims and aspirations to be fulfilled by the state in distant future. They provide the much desired philosophy of the Constitution and give an instrument of instructions to the government to follow the specific policies. The directive principles of state policy are policy contained in Part 4 of the Constitution, that is Article 36 to 51. Many of the provisions correspond to the provisions of the International Convention on Economic, Social and Cultural Rights (ICESCR). Some of the ICESCR rights, for this instance the right to health, Article 12, have been interpreted by Indian Supreme Court to form part of the right to life under Article 21 of the Constitution, thus making it directly enforceable and justiciable. As a party to the ICESCR, the Indian Legislature has enacted laws giving effect to some of the treaty obligations, and these laws are in turn enforceable in and by the courts. Module 2 Objectives of the Directive Principles of State Policy. The purpose of directive principles is to fix certain social and economic goals for immediate attainment by bringing about a non-violent revolution. The following are also the objectives of the directive principles of state policy. Number 1. Welfare state. The Constitution envisages the establishment of a welfare state at the federal level as well as at the state level. In the welfare state, the primary duty of the government is to secure the welfare of the people. Number 2. Social revolution. The directive principles of state policy set forth the humanitarian socialistic precepts that were the aims of Indian social revolution, that is, right to work for an egalitarian society where there is no concentration of wealth, where there is plenty, where there is equal opportunity for all to educate, to work, to livelihood, and where there is social justice. Number 3. Emphasizes the ideals of preamble. The directive principles emphasizes in amplification of the preamble the goal of the Indian polity is not laissez-faire but a welfare state, where the state has a positive duty to ensure its citizens social and economic justice and dignity of the individual. Part 4 contains 19 articles from Article 36 to 51. They could be broadly divided into 4 heads, namely social policy directives, number 2 principles of administrative policy, number 3 socio-economic rights, and number 4 principles of international policy of country. Module 3 Overview of the directive principles of state policy. The directive principles may be said to contain the philosophy of the Constitution. The idea of the directives being included in the Constitution was borrowed from the Constitution of Ireland. For the purpose of understanding, they may be divided into following heads. Number 1. Social policy directives. The concept of social justice, which the Constitution of India engrafted, consists of diverse principles essential for the orderly growth and development of personality of every citizen. Promotion of social order. The objective of every government under Article 38 is to secure and protect effectively a social order, economic and political, is provided to the people in the national life. Article 39 is to secure proper distribution of material resources to the community as to best subserve the common good, equal pay for equal work, protection of childhood and youth against exploitation. Article 39A provides for equal justice and free aid. These articles, read with Article 41, which calls for right to work, education and public assistance for weaker sections, makes it a duty of the state to grant pension to retired government servants as well as their dependents, better industrial relations. Article 43A to better industrial relations, particularly relating to workers, right to free and compulsory education. Article 21A was inserted in the Constitution by 86th Amendment Act 2002 to bring free and compulsory education as a part of fundamental rights. In Unni Krishnan versus State of Andhra Pradesh, Supreme Court explicitly declared that Article 45 has to be implemented by the government. In 2005, the Right to Education Bill was tabled in the Parliament, which was finally passed in 2009 as Right to Education Act 2009. Uniform Civil Code. Also, provision Article 44 for the Uniform Civil Code to harmonize social relations as enshrined in Part 4 in the famous cases of Muhammad Ahmad Khan versus Shah Banu Begum and Sarla Mudgal versus Union of India. The Supreme Court lamented the failure of the government to fulfill the obligation as imposed by Article 44. However, in the case of Lily Thomas versus Union of India, Supreme Court clarified that its lamenting did not amount to issuing the directives to the government to pass a uniform civil code. Right to health. The right to health and raising the levels of nutrition has its beginning with Article 47. Number 2, principles of administrative policy. To foster the involvement of individuals throughout the nation in the processes of democratic government and to gather the villagers' participation, Article 40 called for the organization of village panchayats was inserted. Article 50 on the other hand provide for the complete separation of judiciary from executive. The ideas so evolved culminated in the passing of the Constitution's 73rd and 74th Amendment Acts 1992, which inserted Part 9 and 9A in the Constitution, while Part 9 relates to the panchayats bringing Panchayati Raj, Part 9A relates to the municipalities. Article 50 provides for the separation of judiciary from executive. Third, socio-economic rights. Directive principles of state policy were to build society on the socialistic pattern in the words of Pandit Nehru himself. Article 41 to 43A and Article 46 to 48 specifically target the working sections of the nation as well as scheduled castes, scheduled tribes and other weaker sections of the society, and provide for the betterment of the workers and their living conditions, providing for the right to work, to education, humane working conditions, maternity relief, raising level of nutrition and standard of living, etc. In the case of Hanif Qureshi versus State of Bihar, the court held that the prohibition of slaughter of any of the species of cattle mentioned and held that such a prohibition is not an unreasonable restriction on the right of individual to carry on trade of his choice. Fourth, principles of international policy. Article 51 clearly indicates the state to maintain international peace and security, foster amicable solution of disputes and maintain just and honorable relations between nations. Module 4. The doctrine of separation of powers. The concept of separation of powers runs throughout the Constitution of India, although the term has not been mentioned even once. It is a doctrine which is fundamental to the concept of state and to the concept of constitutionalism, insofar as it prescribes the appropriate allocation of powers. Lord Acton has once aptly stated, "Power corrupts and absolute power corrupts absolutely." Separation of power is a way of restraining the amount of power in the hands of any group or faction, making its abuse more difficult. Separation of powers is a term coined by French politician, Enlightenment thinker Baron de Montesquieu, is a model for the governance of democratic states. There are three distinct activities in every government through which the will of the people are expressed. These are legislative, executive and judicial functions of the government, and they are to be performed by the legislature, executive and judiciary. The legislature makes the laws, the executive enforces them, and the judiciary applies them to the specific cases arising out of the breach of law. Thus, it has become a model for the governance of democratic states. This model is also known as Res Politica. The separation of powers doctrine does not insist that there should be three institutions of government, each operating in isolation from each other. In fact, it is essential that there be a sufficient coordination between each institution of the state. It is for the executive, for the most part, to propose legislation for Parliament's approval. Once passed by the Parliament and given the President's assent thereto, the legislation becomes an act and thus a law to be upheld by the judiciary. A complete separation of these three institutions could result in legal and constitutional deadlock. Rather than a pure separation of powers, the concept insists that the primary functions of the state should be allocated clearly and there should be checks to ensure that no institution encroaches significantly upon the function of other. Under the Constitution, the executive powers are vested with the President, the legislative powers with the Parliament, and the judicial powers with the judiciary, the Supreme Court, the High Courts and the subordinate courts. Module 5. The Legislature. The Constitution of India provides for a bicameral parliament consisting of the President and the two houses known as Council of States, Rajya Sabha, and the House of People, Lok Sabha. The President. The President of India is elected by an electoral college consisting of the elected members of both houses of Parliament and the elected members of legislative assemblies, that is popular houses of the states. Though the President of India is a constituent part of the Parliament, he does not sit or participate in the discussions in either of the two houses. There are certain constitutional functions which he has to perform with respect to Parliament. The President summons and prorogues the two houses of Parliament from time to time. He has the power to dissolve the Lok Sabha. His assent is essential for a bill passed by both houses of Parliament. When the Parliament is not in session and he is satisfied that circumstances exist which render it necessary for him to take immediate action, the President can promulgate ordinances having the same force and effect as the laws passed by the Parliament. The Houses of Parliament, Council of States, Rajya Sabha. The Rajya Sabha is to consist of not more than 250 members. Of these, 12 are nominated by the President for their special knowledge or practical experience in the matters such as literature, science, art and social service. The remaining seats are allocated to the various states and union territories, roughly in proportion to their population. Each state is however represented by at least one member. The representatives of each state in Rajya Sabha are elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of single transferable vote. The minimum age for the membership of House is 30 years. The Rajya Sabha is not subject to dissolution, but as nearly as possible, 1/3 of its members retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by the Parliament by law. The normal term of office of a member of Rajya Sabha is 6 years from the date of election or nomination. House of People, Lok Sabha. The Lok Sabha, as the name itself signifies, is composed of representatives of the people chosen by direct election on the basis of adult suffrage. The maximum strength of the House envisaged by the Constitution is 552, up to 530 members to represent the states, up to 20 members to represent the Union territories, and not more than 2 members of the Anglo-Indian community to be nominated by the President if, in his opinion, that community is not adequately represented in the House. The total elective membership of the House is distributed among the states in such a way that the ratio between the number of seats allotted to each state and the population of the state is so far as practicable the same for all states. The qualifying age for the membership of Lok Sabha is 25 years. The Lok Sabha, unless sooner dissolved, continues for 5 years from the date appointed for its first meeting, and the expiration of the period of 5 years operates as dissolution of the House. However, while a proclamation of emergency is in operation, this period may be extended by Parliament by law for a period not exceeding 1 year at a time, and not exceeding in any case beyond a period of 6 months after the proclamation has ceased to operate. Functions. The cardinal functions of the legislature include enacting of legislations, overseeing of administration, passing of budget, ventilation of public grievances, and discussing various subjects like development plans, international relations, and national policies. All legislation requires the consent of both houses of Parliament. In the case of money bills, the will of the Lok Sabha prevails. The Parliament is also vested with the power to initiate amendments in the Constitution. The various states also have their respective legislatures. The Legislative Assembly, Vidhan Sabha, and the Legislative Council, Vidhan Parishad, in a few states. The legislative powers with the Parliament. Module 6. The Executive. The second but most powerful organ of the government is the executive. It is the organ which implements the laws passed by the legislature and the policies of the government. The rise of welfare state has tremendously increased the functions of the state and in reality of the executive. In common usage, people tend to identify the executive with the government. In contemporary times, there has taken place big increase in the power and the role of executive in every state. In a broad sense and collective sense, the executive organ embraces the aggregate or totality of all the functionaries and agencies which are concerned with the execution of the will of the state, as that will has been formulated and expressed in the terms of law. Thus, the executive includes the political executive, ministers and the head of state, and the non-political permanent executive, civil service servants or bureaucracy. The political executive performs the functions of making policies and ensuring that all the laws are properly enforced by the departments of the government. The permanent executive, that is bureaucracy or civil service, runs the day-to-day administration and works in government departments. It works under the supervision and control of the political executive. The executive power is vested mainly in the President of India as per Article 53(1) of the Constitution. The President enjoys all the constitutional powers and exercises them directly or through officers subordinate to him as per the aforesaid Article 53(1). The President is to act in accordance with aid and advice tendered by the Prime Minister, who leads the Council of Ministers as described in the Article 74 of the Constitution of India. The Council of Ministers remains in power during the pleasure of the President. However, in practice, the Council of Ministers must retain the support of Lok Sabha. The President is responsible for making a wide variety of appointments. The President is de jure the Commander-in-Chief of Indian Armed Forces. The President of India can grant a pardon to or reduce the sentence of a convicted person for one time, particularly in cases involving punishment of death. The decisions involving pardoning and other rights by the President are independent of the opinion of Prime Minister or the Lok Sabha majority. In most other cases, however, the President exercises his or her executive powers on the advice of the Prime Minister and his Council of Ministers. The main functions of executive are: 1. The enforcement of laws, 2nd. To make appointments as per Constitution, etc. 3rd. To make treaties with other countries. 4th. To defend and preserve the unity and integrity of the country. 5th. To formulate foreign policy and conduct foreign relations. 6th. To make law under the system of delegated legislation. 7th. Financial functions. 8th. Semi-judicial functions as to grant pardon, etc., appointment of judges, tribunals, etc. Module 7. The Judiciary. The Judiciary is that branch of state which adjudicates upon conflicts between state and institutions, between state and individual, and between individuals. The Judiciary is independent of both Parliament and Executive. It is this feature of judicial independence which is of prime importance in relation to the protection of liberty of the citizen against the executive. The Constitution of India provides for a single integrated judicial system on pyramidal form, with the Supreme Court at the apex, High Courts at the middle or state level, and the District Court at the local level. It also provides for an independent and powerful judicial system. Judiciary in India acts as the guardian or the protector of the Constitution and the fundamental rights of the people. All the courts in the Union of India are under the control of the Supreme Court, and the decisions of the Supreme Court are binding on all other courts within the territory of India. Supreme Court. The Supreme Court is the highest judicial court in India. It consists of one Chief Justice and other judges as are prescribed from time to time. They are appointed by the President of India. A judge continues to remain in office till the age of 65 years. He may be removed by the President of the Republic on a report of Parliament on grounds of proved misbehavior or incapacity as provided in Article 124. The Supreme Court has original, appellate, writ, advisory and other jurisdictions. According to Article 131, the Supreme Court has exclusive original jurisdiction in any dispute between number 1, the Government of India and one or more states, or number 2, the Union Government and any state or states on the one side and one or more states on the other, and number 3, 2 or more states if the dispute involves any question whether of law or fact. Under Article 132, 133, 134, an appeal lies to the Supreme Court when the High Court certifies that the case involves a substantial question of law as to the interpretation of the Constitution. An appeal lies to the Supreme Court from High Court in regard to civil matters if High Court certifies that the case involves a substantial question of law of general public importance. An appeal lies to the Supreme Court in criminal matters when the High Court reverses the acquittal order of the lower court and sentences him to death. Under Article 32, the Supreme Court of India is the protector of the fundamental rights of the citizens. It may issue writs in the nature of mandamus, prohibition, habeas corpus, certiorari and quo warranto for the enforcement of the rights and liberties of the people. Under Article 143, the President of the Republic can refer to the Supreme Court any question of law or fact of public importance for its opinion, and the Supreme Court may report to the President its opinion thereon. Under Article 136, the Supreme Court may grant special leave to appeal from the judgment of any court of India. The Supreme Court is the interpreter and the guardian of the Constitution of India. It can annul unconstitutional laws and orders of the Union and the state governments contrary to the Constitution. High Courts. The Constitution of India envisages a High Court for each state. Parliament may, however, by law establish a common High Court for 2 or more states. Each High Court consists of a Chief Justice and other judges as the President of India may determine from time to time. The judges are appointed by the President in consultation with the Chief Justice of India and the Governor of the concerned state. The judges retire at the age of 62. Every High Court enjoys original, appellate, supervisory and writ jurisdiction with respect to revenue and its collection, cases of succession, divorce, etc. The High Court is empowered to interpret the Constitution of India. It can review the laws of the state legislature and may declare them null and void if they are contrary to the provisions of the Constitution. Subordinate courts. There are subordinate courts below the High Court in each state. These courts are under the complete control of the High Court. The lower court, for example, Nyay Panchayat or Munsif Court, deals with the minor cases, while the higher courts, example Subordinate Judges Court or District Judges Court, deal with the important cases. Appeal lie to the higher courts from the lower courts, and appeal may also lie to the High Court against the decisions of the District Judge Court or Sessions Judge Court. Module 8. Conclusion. The sanction behind the directives is of course political and not juridical. Though these directives are not cognizable by the court, and if the government of the day fails to carry out these objectives, no court can make the government implement them. Yet, these principles have to be declared to be the fundamental in the governance of the country. The 3 organs of the state have the responsibility to enforce the constitutional provisions and the establishment of the welfare state, as was dreamed by our forefathers. So, you have got a detailed idea about the directive principles of state policy, the legislature, the executive and the judiciary. If you have missed any of the lectures in this series or modules, you may log on to our website www.cec.nic.in for LOR or frequently asked questions, assignments and many more. I will again meet you in another session with more learning lectures in the coming episodes. So, till then, keep learning. Thank you.